Okay. Alrighty, so let's go. So this is on ethics, okay, laws and practices in real estate. And so number one, the fair housing law that first protected people against discrimination in housing based on race was Civil Rights Act 1866, Civil Rights Act 1968, Executive Order 11063 of 1968, 62, or Title 8 Amendment to the Fair Housing Act.
Is D or B?
Okay, so we have choices, either B or D. Okay, so
Should be A.
A, correct answer. Ding, 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 ding.
It is A? Okay.
Because the key here is first protected, okay, and the next one based on race,
Mhm.
Oh, okay.
right?
Yeah.
So basically, the Civil Rights Act was the first housing law. It was a housing law on everything. I mean, it was a law on everything, but it was the first housing law protecting people against discrimination. All right. Okay, good. So now we'll go to number two. The class is protected against, yes? The class is protected against discrimination by the Fair Housing Act of 1968 are A, race only, B, religion and gender only, C, race, color, religion, national origin, or D, age and gender.
C.
And the C's have it, ding, 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 ding. The answer is race, color, religion, and national origin. Good job.
Oh, I got this wrong. I thought it was race and color only. That's how in the book. That's why I keep going. I guess, thank you. Yeah, I was wrong.
No, race and color is only Civil Rights Act of 1866.
Oh, 66. That's what I got wrong. Okay,
All right.
got it.
Fair-
Thank you.
And the Fair Housing Act of 1968 is all four.
Oh, gosh, yes. Thank you.
You're welcome. Everybody okay? All right. So we're going to mute. All right. So now we're going to number three. An agent tells a prospective buyer that a seller will not provide any assistance in financing when in fact the seller financing is available. If the buyer belongs to one of the groups protected by the fair housing laws, the agent may be guilty of which type of illegal discrimination? A, steering, B, discriminatory misrepresentation, C, redlining, or D, providing unequal services?
Redlining.
No. Anybody else? I'm not sure where we ended here. So we've got Lisa that says D. Okay.
I think D or B. I'm not sure which one though.
Yeah, B looks.
Choices. Those are the correct choices out of all four. So now you need to decide which one is the correct answer.
I guess D probably.
Okay. I have a D, I have a B, and then I have a B and D.
Yeah, but B and D is no choice, right? So
So it's one of them. So you gotta cancel it out.
yeah,
now.
Hearings,
we can't say
hearing?
discrimination here because we don't know what is discrimination here. Unequal service looks better. D.
Okay, so we've got the
I
final
would say
answer
A.
on some people. Go ahead. So Sean,
Steering. Steering?
nope.
Discriminatory provide on service. I think it's a D.
Okay, so we've got about 3 Ds. So the final answer, Ravender, ding, 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 ding. B,
Oh, B.
discriminatory misrepresentation.
Oh.
Okay, what were
Okay.
you misrepresenting?
Oh, now I see that. Yeah.
Well, you
The
had
seller
you
financing.
said B, right?
No,
So
he said D.
he said dog. Okay, so dog or boy?
Yeah, I said B or D.
Okay, dog. So we're gonna go apple, boy, cat, and dog. All right.
So what's the correct answer? It's B?
The correct answer is discriminatory misrepresentation.
Okay. Okay.
Okay. And so now my question to you is, what was the misrepresentation? What were they
Because it was the financing was
Discrimination
available.
against seller, like because seller wanted to finance, but they said it's not.
Okay, so yes, they were misrepresenting about the seller financing. That's what they were misrepresenting. All right, just so we all know what we were talking about. All right, number 4. Which of the following actions represent discriminatory advertising? So A, telling the prospect buyers about the positive and negative aspects of a certain neighborhood. B, telling a prospective seller that now would be a good time to put property on the market. C, advertising a property is available to individuals of a particular race. And D, telling a prospective buyer that the agent is too busy to show the buyer properties personally on a given day. Oh my God, somebody's going to come out on this one. What was her name? All right, so we all got
This
the correct
is C.
answer. C
Number
is correct.
C, yes. Yeah.
Cat is correct.
Red will.
Advertising property.
Abi.
All right, folks, please watch your microphones. Okay, so cat C, advertising a property as available to individuals of a particular race is the correct answer. All right, and everybody got that right? Ding, 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 ding. Okay, number 5. Which of the following is an example of block busting? An agent shows a minority home buyer properties located in a neighborhood where there are no minority homeowners. B, an agent persuades a minority home buyer to avoid looking in a neighborhood where there are no minority home owners. C, an agent persuades a family to put their house on the market because ethnic minority families are beginning to move into the neighborhood. Or D, an agent persuades a minority home buyer to buy a property located in an area where most of the homeowners belong to minority groups.
D.
No.
C.
C is the correct answer. Ding, 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 ding.
Oh.
Okay, because block busting is we're saying you have to put your house on the market because the value is going down because the minority people are moving into the neighborhood. All right, everybody good with that?
Yep.
Number
Yep.
6. Okay, good. Number 6. What is the significance of the Jones versus Mayer Supreme Court decision? A, it provides that anyone seeking to buy or rent a residential property who feels victimized by racial discrimination may take legal action under the 1866 Civil Rights Act. Or B, it allows for certain exemptions to the Title VIII prohibitions against discrimination, provided there is no broker involved in the sale or lease transaction. Or C, It established that brokers and lenders must indicate their compliance with fair housing laws by displaying a standard HUD poster. Or D, it added gender, age, and familial status to the groups protected against discrimination in housing.
A.
I think A, racial discrimination.
Oh boy. Between Jones and May Supreme Court decision. D looks good too. It's added. Oh boy.
Yeah, D. I think it's D. Yeah, probably.
I'm lost in it.
Remember, trust your gut. This is the time to start trusting yourselves and start
All right.
trusting your guts. This is not,
Because that was to prevent racial discrimination, right? To prevent, yeah, so it gotta be like D, I think. Against.
Yeah, but this A is, I think, talking about race.
Oh, racial discrimination.
Yeah, I guess A.
Could be A or D.
all right, so we're gonna stop now. Okay, so the answer is A. It provides that anyone seeking to buy or rent a residential property who feels victimized by racial discrimination may take legal action under the 1866 Civil Rights Act. All right, because that's what Jones versus Mayer was all about. The real estate company would not sell or lease. I'm not sure, I'm getting it mixed up, but anyway, they would not sell to Mr. Jones because of the race. All right.
This happened in the 1900s, though, right? This
This
case took place in the 1900s, right?
happened. When did it happen?
It had to be during the Civil Rights Act, no?
All right, now I gotta look it up because I don't know it offhand by heart. So give me a second because I want to get it right.
Okay.
Because I don't want to get it wrong.
I think 1968.
That's
19
what I was
Oh.
thinking during the Civil Rights Act,
during the Civil Rights Act, yeah.
during the housing time. All right, and of course now when I need to find it, I
So
can
it provides that anyone seeking to buy a residential was victimized by race make legal under
anti-
1866.
All right, so all right, why can't I find it? I should know it by heart, but I don't. Actually, my brain is going kaplooey on me. Workers' compensation. Well, I'm in the right direction, but not the right page. Okay. Megan's Law, offsite, misrepresentation, consumer. Everything but what I need. That's interesting. I should have put that in.
It
here.
is 1960. I just looked it up too.
Okay. So why is it not in here? Okay, it must be in chapter 4 then. Must be in chapter 4. Yep, there it is. Okay, so here, the 1968 Supreme Court decision, Jones versus Alfred Mayer, affirmed, okay, affirmed means that it confirmed, okay, that the Civil Rights Act of 1866 prohibits all racial discrimination, private and public, in the sale and rental of property, and there are no exceptions, okay? But the other part of it too is that it also stated that personal property is also included. So we're not just talking about real estate, but we're also talking about personal property, meaning the clothes on your back. All right, so that was one of the other things that came out of it. All right, so number 7, a home seller tells the listing agent that he will not consider any offers from minority buyers. A cooperating broker wants to show the home to a minority buyer, but learns from the listing agent of the seller's instructions. The cooperating broker then informs the buyer that he cannot show that home to him. The buyer subsequently asks to be shown only houses that are in minority neighborhoods. Which parties in this scenario are probably liable for violating the fair housing law? A, the seller only, B, the seller and the listing agent only, C, the seller, the listing agent, the cooperating broker, or D, all four parties.
D.
All right, so we're at 30 seconds now. We're on number 7, and the answer is C.
D.
C. Why would it be D?
कहाँ 4 now and all 3
By mistake.
all 3.
Right? There's no reason for it to be D, because you're correct, Lisa. The buyer can ask for whatever they want, but the actual people that violated the law was the seller, the listing agent, and the buyer agent that told them that he or she can't show that property. Right? The buyer could do whatever they want to do. All right, so the correct answer is C. Okay, next, the practice of redlining is specifically prohibited by what? The Home Mortgage Disclosure Act, the Real Estate Settlement Procedures Act, the Civil Rights Act of 1866, or the Americans with Disability Act. Okay, so I have a B, I have a D. I believe I might have a C, but I'm not sure.
It's B.
Yeah, I said C. I don't know. I said C. That's my answer.
B is your answer, as in boy,
Cat.
as in cat. Okay. Okay, so we have cat, we have boy, and we've got dog. Nobody else wants to join in?
It's related to fair housing, so
Okay, so redlining is mortgages,
mortgage.
and therefore it is the Home Mortgage Disclosure.
Oh, so A. Okay.
A is the correct answer. Okay. All right. Title 8 of the Civil Rights Act of 1968 applies to the sale of all single-family residences, all privately owned single-family residences, privately owned single-family residences listed with a broker, or privately owned single-family residences for sale by owner.
A.
All single-family residences? No. Okay, I have a lot of A's and I have a lot of C's. The C is the
Mm.
correct answer. If that's what you were answering. Cat, 9, cat, privately owned single
Yeah, 9 is C. Well, I think, I don't know. C.
residences listed with a broker.
Hmm.
Right? So the Civil Rights Act, Title 8, the Civil Rights Act of 1968, which is fair housing, applies to the sale of privately owned single-family residences that are listed with a broker. Okay. All right, number 10. A broker signs a listing agreement to sell a home for $100,000. An immigrant couple are interested in the house and ask the agent the price. The agent states the price is $110,000. According to the fair housing law, such an act is what? Illegal because the agent changed the terms of the sale to discourage this particular couple. Illegal because the agent violated the listing agreement. Illegal because the quoted price increase did not exceed 10% of the listing price, or legal because the increased price does not necessarily exclude the couple.
Uh-oh, I think I want to change my mind. B. Oops,
Okay.
never mind.
I think it's A.
Okay, so for those of you that chose A, ding, 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 you know what
It was.
it's about, right? And you know what the law is, all right? And that is illegal because the agent changed the terms of the sale. Are we allowed to do that?
No.
Nope, it's discrimination.
No. Wait, we're talking about ethics for agents here, right? So it's
Yeah.
illegal because the agent changed the terms of the sale. Okay, number 11. Which of the following actions is allowed under federal fair housing law? A broker, following the instructions of the seller, advertises the property as for sale to Christian families only, or a home seller, acting without a broker, places a for sale, mature single men only sign in front of the house, or the owner of 4 rental houses advertises one of the properties for rent to married couples, no children, no pets, or the owner of a duplex who resides in one of the units refuses to rent the other unit to a non-Christian family.
Federal Fair Housing Law.
તે શું છે ક્રિશ્ચિયન ફેમિલી ઓનલી તો ના ચાલે ને
ના ચાલે આ બીજું બી
Which of the following actions is allowed? I think this one B. I don't know.
All right, so we are on number 11. So I think I see a D, a C, and a B. Melissa, are you firm on your D answer?
Yes.
Okay, so the answer is D. The owner of a duplex who resides in one of the units refuses to rent to a non-Christian individual. Everybody good with that? Any questions regarding that? Now is the time to start talking and start asking questions and figuring these things out. All right, number 12. May Southfield believes a real estate agent has kept her. I'm going to actually put in the number 12 here so that now we know where we're at and I know where to look for the answers. Okay, May Southfield believes a real estate agent has kept her from seeing a certain property for rent because she is a woman. What actions should she take if she wants legal satisfactions for her complaint? A, file charges for illegal discrimination with the police department that has jurisdiction over the local area, or file a complaint with HUD and file suit against the offending parties in state or federal court within the prescribed time, or wait 2 years and then file a civil suit in federal court, or file a civil suit in federal court to force HUD to enforce the Fair Housing Amendment.
I'll go by B.
And that's a great choice. Ding, 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 everybody. You did good. B is the correct answer. So what is the prescribed time period to file that complaint?
2,
2 years.
2 years.
1 year after.
Ravinder, what did you just say?
1 year.
1 year. Ding, 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 ding. Okay. And federal, to file a federal lawsuit,
2 years.
2 years. Ding, 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 ding.
So civil is 1, federal is 2.
HUD is 1 and
Oh,
federal
how did you?
2. Okay, so now we're on 13. Okay, so John Dunbar hires Betty Jones to sell his house with the condition that he will not be the first one in the neighborhood to sell to members of an ethnic group. What should Betty do about this condition? Inform Dunbar that the condition is illegal and she cannot comply. B, note the condition on the listing agreement and have Dunbar initial it. C, pretend that she did not hear the condition and proceed to market the property to all groups. Or D, inform that she will try to discourage members of that group from looking at the property, but she cannot control cooperating brokers.
A.
Ding, 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 ding. A is the correct answer. Good job. Good job. All right. So under federal fair housing laws, the owner of a 10-unit apartment building may legally A, advertise that property is not available to anyone requiring wheelchair access. B, refuse to rent to aliens. C, require families without children to pay the same security deposit that families with children must pay. And D, require tenants to move out when they become 62 years old.
C maybe.
All right, ding, 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 ding to all the C's. Good job. Okay, require everyone to pay the same security deposit is the correct answer. All right, so now number 15, okay, for ethics. Under what conditions would federal fair housing laws allow a homeowner to refuse to rent to a family because they have children? The owner has a consistent no children policy in all her rental properties. The owner can prove that costs to repair damage caused by previous tenants with children exceed the tenant's security deposit. C, it is a single family house that is part of a federally designated planned unit development. Or D, it's a single family house and the owner owns only one other rental home in addition to his own residence.
I'd say A, but I could be wrong.
Okay, so we have an A.
Yeah, I was thinking A too.
Okay, we have an A. We have 2 A's. Oh, we have 2 B's and we have a C. Okay, so we're all over the place. All right, so it's been 30. So the answer is D. It's a single family house. The owner owns only one other rental home in addition to his own residence, and therefore they would be able to refuse to rent to families. So again, if we go to the, give me a second here.
Oh.
The reading. I know I have it in my chart. I have it in my chart, but let's go to chapter 4. And it is in page 69. Whoops.
I thought the owner is supposed to be living in same complex or same like 2-3 family house.
No, here it is.
Yeah.
Wait, it's in this area here. Okay, here we are. So we're in this area here.
What page is that?
Oh, that's redlining.
68 the page.
There it is right there.
Thank you.
Exemptions. There it is right there.
Okay.
Does not own more than 3 homes. That's the first one right there. The sale or rental of a single family home is exempted. That's the key word. When the home is owned by an individual who does not own more than 3 homes
Oh,
at one time.
I see.
Nope, that's it right there. All right. So you all did good. Okay. You need to brush up a little bit. Okay. But basically y'all did very good on that. I didn't keep track of, all the correct answers, but just in general, I believe it was primarily all good answers. All right. So now we're going to skip this right now. How you feeling?
Excuse me, Miss Gloria, can I ask you something real quick before we continue?
Okay. Yes, Cecilia, what? I'm sorry.
I'm sorry, I said I just wanted to ask you something real quick that I wasn't entirely sure of. So I started midway, like around chapter 16, right?
Okay.
So when I had studied over the weekend, I had studied 16, 17, 18 and made the flashcards for that. Do I still go according to that or still do like reviews with you of the stuff I haven't learned yet?
So the answer is it's going to be your choice whether you want to stay here to do the review. Okay. So that's your choice.
Okay.
That's all that I can tell you. You don't have to be here.
Okay. But I could still just review the stuff then that we have done though. Like I could still just, because my thing is, since I started midway, should I just continue with the basically the study and the flashcards of what I did review with you, and then just I guess review this when it comes back around? Because
Okay.
I don't want to get too confused.
All right. No, I get that. And that's why I'm saying, you don't have to be here. You can be if you want to, but you don't have to because this is review. Although we are reviewing the main chapters 1 through 4 in question format. But again, my answer to that would be, I would tell you to start reading from the beginning of the book. And so that when the next class starts, then you'll be a little bit ahead and it'll make a little bit more sense.
Okay, and let's say if I decided not to do at least this review with you guys, will it affect my hours? Will that back it up more?
No, because you're going to have to catch up on the review on when you get to your okay, 16. So no, you should be good when you get to chapter 15 on the next section.
Oh, okay, so I'll still be caught up if I didn't, like, let's say, at least, like, let's just say for today, if I didn't do the review and I wanted to do my own, like, for 16, 17 on my own today, that's not gonna really affect me then when it comes to my hours?
No, it should not.
Thank you so much, because I was freaking out a little bit yesterday, even though I was answering questions.
Oh, okay, no worries. No, don't worry. But no, that should not affect it.
I have a
Okay,
quick
thank you
question
so
related
much,
to
Victoria.
that,
I just really
Roya.
wanted to know.
Okay, I'm sorry.
I have a quick question related to same topic.
Okay.
Those review hours, do they actually count towards the 70 something hours you have to complete?
The answer is that the answer is that it, there is no real answer. Let me phrase it to you that way. There is no real answer, because if you're doing the review now, then the answer is it's going to apply to your hours, but you're not going to be able to do anything until you get to your chapter. Okay. And for a lot of people, these reviews really don't mean too much. And so I have no answer to that. And the school doesn't have a policy on that. So my
Okay,
answer,
no problem. I'll attend all week except Friday, since Friday is the exam.
Friday is the only one you don't need to be here. All right.
Okay.
Right. I personally believe reviews, even though you may not have done the chapters, are a good way to kind of get into the subject of the chapters that you did not cover. But everybody is, everybody has their own what's comfortable for them. So I'm not, saying no, and I'm not saying yes. It's what's going to make it best for you.
Okay, that works.
All right. So
Thank you.
that's my answer. Okay. All right. So now we're going to be doing, like I said, this is from a totally different book. So as you can see, the questions are a lot different. Would you agree on that? Are they a little bit more difficult, making you think?
They're different. I don't think they're difficult, but they're different.
Yeah, they look very different.
Okay. So, all right. So here we go. The state real estate license laws set a minimal level of competence for real estate professionals, and in addition, A, establish commission and fee schedules, B, set ethical and professional standards, C, limit the number of brokerages that may operate in the state, or D, prescribe methods of obtaining real estate.
B.
B. Okay, we got the B's. The B's have it. All right, ding, 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 ding. Good job, everybody. Okay, number 2. Okay, a particular real estate activity generally requires a license if it involves a buyer and a seller, or concerns a transfer of title, or results in a taxable event that must be reported to state and federal agencies, or is performed for another party for compensation.
D.
Okay. I'll have a B, I have a D. Oh, I have two D's and 2 A's. 3 D's. And the D's have it. Okay, is performed for another party for compensation. Okay. Number 3. Okay, Mary is selling her house. Betty wants to buy it. Margaret intends to help Mary and Betty with the sale contract. In return, Mary will send her son to paint Margaret's house. So which of the following circumstances will probably allow Margaret to help Mary and Betty without holding a real estate license? A, Margaret and Mary are sisters. Betty is Mary's daughter. C, Margaret is Mary's attorney. Or D, Margaret works in the office of a licensed broker.
I say C.
C as well.
All right, so I have 3 answers, 4 answers, 5. All right, and the C's have it. Ding, 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 ding. Margaret is Mary's attorney. Again, keyword is intends to help with the sale of the contract, which tells you that right there. Okay, number 4. An active broker's license generally authorizes the holder to perform services. A, within the area administered by the local real estate board. B, anywhere in the state. C, anywhere in the country. Or D, in neighboring states as well as the issuing state.
B.
B.
Everybody's got it. Ding, 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 ding. Anywhere in the state is correct. Number 5, which of the following is the only capacity in which a licensed salesperson may act? A, as agent for the seller. B, as agent for the principal who has signed a listing agreement. C, as agent for one or more licensed brokers, depending on the transaction. Or D, as agent of the employing broker.
D.
D, ding, 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 ding. The D's have it. Good job. If a licensee's license is voided, the licensee may continue performing those services already in progress at the time of the voiding. Or B, the licensee may not practice real estate. Or C, the licensee may never obtain another license in the same state. Or D, the licensee may only work for another licensee with a valid license.
B.
Okay, looks like everybody else got that answer too. Correct. B is the correct answer. The licensee may not practice real estate. Okay, number 7. To obtain a real estate salesperson's license, an individual must A, pass a state license exam. B, have previous experience as an assistant to a licensed salesperson. C, be currently employed by a licensed broker. Or D, be sponsored by a licensed salesperson.
C.
C, I guess.
To obtain a real estate salesperson's license, what must you do?
Oh yeah, A.
A.
A, ding, 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 ding. Okay. 8, Carl's broker's license is revoked by the state commission. Lily, a licensed salesperson working for Carl, must A, continue to perform services for her clients pending Carl's reinstatement. B, cease performing real estate services. C, go to work for another employing broker. Or D, obtain a broker's license.
Changing my answer from A to B. Sorry, some B to C.
All right.
B, I guess.
C, B's, and the B's have it. C's performing real estate license services. Number 9.
I'm confused by this one, right?
You're confused.
Because Lily can go work for another broker. To me, cease performing services means you have to stop selling real estate.
You can't
Okay.
work if your broker doesn't have a license.
Okay, I feel like this one could have been worded differently.
Well,
That
there's
makes
lots of
sense.
things that can be worded differently. The question here is, if the broker's license is revoked, what must the salesperson do or stop doing?
Hmm.
That's the question, right?
Okay.
So if the broker's license is revoked, that salesperson cannot work.
Yeah,
Now-
C would be before it's revoked, right?
Say that again?
I say C can only work like if it's before revocation, you can always change the broker, but not after license is revoked.
Oh, no, they can change.
Yeah, we could check.
Yeah, that's what I'm saying. The C is valid if it's not revoked yet. The license is not yet revoked. then it's fine. They can work for another broker.
Okay, I'm not quite understanding what you're saying, Ravender, because what we're saying here is
No, I'm
that,
saying the A is fine. I'm B is fine. I'm just saying that to answer somebody asked the C. I think C would be only valid like if it's like broker license is not yet revoked. That time anybody can change, switch from one broker to another
change.
broker.
but that's where I'm disagreeing with you. You can change after the broker's license has been revoked. You just have to wait till your license goes to Trenton, and then you can change.
Yeah, you
So-
have to in
No,
order to
but,
keep.
but okay, even if broker's license is not revoked, can we not switch from one broker to another broker by
That's true too.
yeah, that's what I was saying.
Okay,
Okay.
but you're you're making
Okay.
it confusing.
What he's saying is that he agrees with C only if the time period would allow you to. But in the meantime, B is the correct answer because if the license is revoked, you still have to take time in order to sign up with another broker. Right? You
Yes.
can't do
The answer
any real estate
yes.
businesses if the
Well,
license.
But again, okay, so now okay, so everything that you are saying is correct, but now let me just say this. What happens if there was a broker salesperson and they took over the management? Right? They wouldn't have to necessarily go to another employing broker.
Right.
Okay, but doesn't that process take time as well?
Not if there's a broker salesperson, no.
Okay.
The broker
Okay.
salesperson automatically starts to manage paperwork wise, it will take time, but they're a broker salesperson, so they're able to take over immediately,
Gotcha.
right? And of course, they're going to have to file, they're going to have to file with the real estate commission saying that they've taken over, but because they already have a broker's license, they can do that. The timing would be if it was a salesperson who has the closest to 3 years, right? And then is applying for a temporary license, a temporary broker's license, then the timing is going to take effect there.
Got it.
Okay. All right. So, all right. So we got that. So number 9, if the state licensing authority finds that a consumer's complaint against the licensee is justified, the authority may do what? A, issue a money judgment against the licensee. B, sentence the licensee to jail. C, suspend or revoke the license, as well as report the case to an appropriate judicial authority. Or D, negotiate a financial statement with the complainant on behalf of the real estate commission.
C.
Good. The C's have it. Ding, 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 ding. All right. Number 10, to maintain a valid license, a licensee needs to A, generate minimum number of transactions within the licensing period. B, remain in the same agency affiliation for at least 1 year. C, pass the licensing examination on a yearly basis. Or D, satisfy educational requirements for license renewal.
D.
D.
The D's
D.
have it. Ding, ding,
Yep.
ding, 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 ding. Good job. Good job, everybody. All right, so now we're going to go to the next one. All right. Hold on. All right, number 23. All right, let's see what we got for number 23. All right, 23, risk management. Okay, so in which risk management strategy does a party take full responsibility for consequences and enter into an activity in spite of known risks? A, avoidance, B, reduction, C, transference, or D, retention. So this would be if we are going to be managing or being a part of a brokerage company. So it's business management. So we only have one answer, two answers.
I
Okay,
don't
good. We're starting. Good, good, good. Okay, my mistake. All right, so the answer is retention. All right, so we want to
I
retain.
was thinking that too. That it was like,
Well, there you go.
Retention.
Trust your gut. All right, so retention is you want to keep people in the business, right? So your risk management strategy would be to how can we retain or keep the agents in our office? Because we're talking about brokerage, we're talking about the business of real estate. All right, so number 2, the brokerage firm can best reduce the risks that licensees will commit errors and violate laws by obtaining of errors and omissions insurance, or B, hiring only agents with law degrees, or C, disclaiming knowledge of the law, or D, providing professional education.
D.
Yeah.
Ding, ding,
D is in dog.
Yep.
Dog. Yep.
is the
What's the D? Yeah.
providing professional education. Okay, number 3, how does documentation manage risk? A, it shows the public that the office is well managed. B, it serves as evidence that laws have been complied with. C, it relieves agents of the need to remember details. Or D, it keeps office staff too busy to interfere with transactions.
B.
B as in boy.
B as in boy.
B.
Right. Ding, 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 ding. All right, good job. Okay, number 4. A good way of reducing the risk that brokers and sales affiliates will commit errors or inadvertent law violations is to A, establish a company administered system of fines and penalties. B, maintain a comprehensive and up-to-date procedures manual. C, hire only licensees with at least 5 years experience. Or D, have licensees sign an agreement that they take sole responsibility for their actions.
Yeah.
B as in
B
boy.
as in boy.
B. 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 B.
Boy, ding, ding, ding,
Mhm.
ding.
Yep.
All right.
Thank you, Mom.
The risk of committing an unauthorized practice of law can be practically reduced by what? A, having customers and clients provide their own legal forms. Not really. B, avoiding situations that require the use of legal forms. C, using standard forms and contracts prepared by attorneys. Or
C.
D, have an off-staff attorney to be present at the signing of any legal forms.
C, I guess.
Yeah. More like C now.
Okay, so we have more like C. How many of, oh, we got a lot of C's coming in. All right, good. That is the correct answer, right? Using the standard forms and contracts that were prepared by attorneys for us to use. Okay, number 6, transaction records required to be maintained typically include A, road maps, B, photographs of all transaction parties, C, copies of agents' school transaction transcripts, or D, closing statements.
Ah,
D. Dog.
that's it. Dog. Dog. Dog.
Dog, 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 dog. Okay. Number 7, woof, woof. Number 7, what kind of coverage is provided by general liability insurance? So A, coverage for any financial harm caused by the covered licensee, or B, coverage for the property owner's risks incurred when the public enters the insured premises, or C, coverage for property damage caused by a property manager, or D, coverage for financial harm caused by an illegal action of a licensee. Oh, look at you guys. Ding, ding, ding.
I don't know what's B, covered financial harms, illegal action.
Good job, everybody. B is the correct answer. Coverage for a property owner's risks incurred when the public enters the insured premises. Good job, everybody. All right, number 8. Standard E&O policies exclude coverage of damages resulting from what? A, violations of the law. B, negligent performance of a professional service. C, failing to carry out a company policy. D, cooperation with other brokerage firms.
Here, oh gosh. Elimination of omission. What is this? Violation of law, elimination.
What is standard E&O?
Errors and omissions.
Yes, errors.
A, I guess.
Elimination, I say it's error, so it's gonna be
I feel A.
sorry, failing to carry out company's policy. C could be cooperating.
It will be B.
Failing. Failing to
think C.
carry out company's policy, failing. Oh boy, I don't know.
Keyword,
C is the most one.
keyword.
Let's see.
Exclusion.
All right, so we got a C, we got a C, we got an A, and we got an A. All right, so the answer is A. E&O is not going to exclude, is not going to cover anyone violating the law. And violation of the law could be fraud, right? Or discrimination, right? Would that be violation? So the answer is A, violations of the law. Okay,
Yeah.
number 9. Okay, failure to maintain client confidentiality is a risk associated primarily with what? Trust fund handling, office management, agency relationship, or the closing process.
Oh,
Okay, good job for the C's. The cats have it. Meow. The agency.
is it C? Oh man.
Okay, so that's that. Number 10, the lead-based paint disclosure requirement applies to all properties. B, applies to residential properties built before 1978, applies to the seller of the property, not the seller's agent. And D, is mandatory for the seller of a property, but optional for, good job, everybody. B,
Bye.
the correct answer. Okay, number 11, creating a false impression that the licensee is a certified appraiser is a danger in what? Performing a comparative market analysis, writing property advertisements, presenting written offers, or researching owners' documents.
Maybe A.
Okay, so we have an A. We have 2 A's, I think. We have a C. We have another C.
Yeah, C, C, C.
All right, again, like I said, trust your gut. Creating a false impression that the licensee is a certified appraiser.
So I guess it's A because you said that. Trust your gut.
Okay, ding, 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 ding. The answer is A, because it's a comparative market analysis. Where would I be considered, how would I be considered a certified appraiser in presenting a written offer?
What I thought was if you give in writing, you're like you're more in danger.
Appraisers don't present offers.
Correct? Right?
Yeah, I didn't see the present part, but I was going off of offers because the appraiser, when the appraiser comes to appraise the house, they give you the value. They help give you the value of the house, right?
Right, but where does the offer come in?
No, that's why I said I didn't read that part. That's why.
So the only time that it would be is when we're doing comparable market analysis, because we can only give a range, a price range, but a certified appraiser is going to give a certified dollar amount. Okay. Number 12, one of the major risk areas in advertising a listed property is that an advertisement will A, describe the property in excessively glowing terms, B, fail to appear at the same time in all available media, C, omit any mention of the owner's main selling points, or D, make a substantial misrepresentation. A. All right. It could be A or D, okay? But when they're saying one of the major risks in advertising a listed property, then in that case, it would be the excessively glowing terms, okay? All right, which of the following actions can a real estate licensee perform without risking the commission of an unauthorized practice of law? Boy, that's a mouthful. Which of the following actions can a real estate licensee perform without risking the commission of an unauthorized practice of law? So A, give legal advice. B, fill in blanks on a lawyer-prepared contract form. C, charge a fee for preparing a purchase. And the keyword was without risking. Charge a fee for preparing a purchase, or draft in addition to the pre-printed form. That my answer on that one is B. All right, good. The answer is B. Ding, 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 ding. Right, without risking. And so fill in the blanks on a lawyer-prepared contract form is the correct answer. In assisting a party to prepare a purchase contract, it is essential for a licensee to A, use the services of the attorney. B, make sure that the buyer and seller do not make any changes to the pre-printed form. C, sign the contract along with the buyer and seller. Or D, make sure the information in the contract is accurate and that all agreed terms are included. Okay, and the D's have it. Ding, 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 ding.
I have a question here about this one. In my experience of buying properties, every single time I get the contract, there's always been things that's missing. And I'm pretty sure that's why they send it to you before you signed it. But in the event where the agent was to miss something and the buyer missed, or buyer or seller missed something in the contract, who's going to be held liable for that?
Depends on what's being missed. And that's
Okay, I see. Okay.
And that's a legal question, but it would depend on what was being missed. We already discussed it. If it was in the listing agreement, it was in the MLS, and the buyer's agent did not include it in the contract. We already had that question. and the buyer's agent did not include it in the contract, all right, and the seller signed the contract, the seller's agent didn't read it, whose fault is it?
In this case, will be, it's hard to tell. Maybe the seller's agent,
In this case, it would be the seller.
if it's in the listing. Yeah, but if it's related to like down payments or deposits, if the numbers are wrong, is that on the agent or on the buyer?
That would have to be the buyer's agent.
Okay.
Can't write up the numbers. That's why I tell you, everybody, again, it's not an enforceable contract then, right?
Mhm.
The numbers are wrong. If any information is incorrect in the contract, then it would not be enforceable, right? I mean, we're talking about, I mean, again, we are talking about contract law. Obviously, we're not lawyers, right? And again, I mean, I've seen it happen where the lawyers don't catch the numbers either. You know, so I mean, it's
Yeah, that's what I'm concerned about, because I've done this a few times. Every single time something was missing in the contract or something was not calculated properly, and I had to call it out. So at that point, I'm like, is it on me as a buyer to make sure everything is all right, or is it on the agent?
on you. It is on, the finality of it is also on you, because you have to make sure, I mean, you're the one that's buying the property, not everybody else. So the bottom line is you have to do your due diligence as well. Right? So it's
Yeah.
it's as much on you as it is on the other people that are preparing it as well. Okay. All right, number 15. To minimize the risk of violating fair housing laws, a licensee should A, refuse to use terms that refer to or describe any of the classes of persons protected by the law. B, avoid working in neighborhoods that are predominantly occupied by a single ethnic group. C, make discriminatory or derogatory remarks in conversation only, never in writing. And D, give better service to members of a protected class than is standard for other clients or customers. A is the correct answer. I had to reread it. Okay, so A is the correct answer. Do we have more here? Oh, yeah, we do. Okay, number 16. All right. If licensees working for competing firms are overheard discussing commission rates, they are at risk for being charged with what? Commingling, price fixing, insider trading, or redlining?
I'm confused here, but I took my chance. Ah,
Okay, what about the Sherman Antitrust Act?
price fixing. Oh,
Ding, 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 ding.
B.
B
so
is-
it's B. Okay.
Okay, there's no such thing as insider trading in real estate.
No? Okay. I will remember that forever.
So, and redlining has to do with mortgages. Right? So again, you need to know what these words, where do they apply? So
Right.
commingling, where does that apply? It applies to the broker. So that's not a good answer. Insider trading, there's no such thing in real estate. Redlining has to do with mortgages. So the only other answer is price fixing. And again, that comes under the Sherman Antitrust.
Sherman.
All right, number 17. A licensee who knowingly conveys false information about a property is committing what? Intentional misrepresentation, unintentional misrepresentation, accidental fraud, or felonious representation. All right, so the correct answer is A, intentional misrepresentation. Number 18, the risks that attend recommending service providers can be effectively reduced or transferred by what? A, presenting a broad range of choices and letting the consumer make the selection, or B, recommending all the relevant providers listed in the telephone directory, or C, recommending only those providers who are willing to work on a commission split, or D, recommending service providers who have performed well in the past.
It's either of A or D, so probably A. A, I guess.
I say A.
All right, so it's either A or D. We've all agreed on that. And
Which one we working at? I just lost my screen, so I couldn't.
that's okay. Number
Is it
18.
18? Okay, let me just quickly, the risk that.
Risks that attend recommending can be effectively reduced or transferred. Well, my answer is going to be D. I don't have answers for these questions here. So my answer is D, because you're only going to recommend people who have done well by you. But again, when I stated that in the past, I also stated that you need to offer more than at least three people. Okay. So then this way you're recommending people that have done good jobs, but you're giving them a choice of three people. Presenting a broad range of choices and then letting the consumer make a selection, to me, is irrelevant. And the reason for that is, A, we're talking about a broad range of choices. People usually ask for specific service providers. They don't ask for a broad range of people. So that's why I am choosing D. All right, anybody wants to mention, disagree, or
I think I agree with that, yeah.
discuss it?
I think D is a better choice.
All right, so recommending service providers who have performed well in the past. But remember, always recommend at least three people, not less, not less. And within those three people, you are allowed to recommend your own family member. All right, so it's not like you're not allowed to recommend, personal people that you know. But depending on what you're recommending them for, if it's a licensed kind of a job, then that person has to have a license, or have the state certificates, whatever they need for that job. But you can definitely recommend family members, as long as you've recommended other people as well. All right, so that's my answer on that one. Number 19. Which of the following is an area of risk for the licensee regarding the Real Estate Settlement and Procedures Act? So which of the following is an area of risk for the licensee regarding RESPA? So A, forgetting to file a tax form reporting a completed sale. B, failing to be present at a closing. C, failing to make sure the consumer is informed about the rights guaranteed by RESPA. And D, failing to fill out a uniform settlement statement for a client.
That's RESPA.
An area of risk for the licensee regarding RESPA. Okay.
I think C would be better choice.
That's my choice. Now, so just so you understand, this is also national. So there are states that have the real estate agent fill out the settlement statement. So I'm going with just the generic version, and the generic version is the informed about about the rights of RESPA. All right, looks like everybody else
Yep.
agreed to that as well.
Yeah.
All right, so that's that. Okay, the main danger in the area of handling trust funds is the possible commission of the main danger in the area of handling trust funds is the possible commission of separate record keeping or trustor malfeasance or fraudulent credit scoring or
Commingling.
and conversion.
Commingling.
Commingling D. Yes.
That's my answer as well. D,
Yeah.
commingling and conversion as well. All right. So, so that's that. Now let's see, because I didn't have the answers. Did they have? Yeah, I see they didn't have the answers here. So, all right. So that's that. All right. I'll fix that. I'll get that fixed. All right. All right. So we've got about 8 minutes. So let's get into property management. So let me just ask a question, a general question. Property management, what kind of an agent is that person?
General agent?
Specific.
Ding, 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 ding.
No, no,
Yes.
Ah, bravo, bravo. Okay. All right, so let's go into the questions, see what we have here. The general task of a property manager is to A, produce the highest net return for the owner while safeguarding in the property. B, find and retain tenants at the least expense to the owner. C, relieve the owner of all responsibility for operating and maintaining the property. Or D, negotiate rents and regulations between the tenants and the landlord.
I would say C.
See? All right. Let's see. I don't know. I'm between A and C, I think. The general risk of a task of a property manager. No,
I went with A.
I'm going with A also. And the correct answer is A. Right? What
I
is
think it's
your job as a property manager? Right? Your job as a property manager is to get the most money for the owner of the property, right? You are not relieving the owner of responsibility for operating and maintaining the property. That's not your job. Okay? You're not relieving them of that job. So A is the correct answer. Your main job is to make sure that their property is profitable and your owner will say A. And that is the correct answer, Lisa. Because that is the exact job description. All right. Financial reporting. Financial reporting is a duty imposed on the property owner by the IRS. A function usually outsourced by the owner to a CPA. C, a fundamental responsibility of the property manager. Or D, a property management technique used to ensure that tenants pay the correct amount of rent.
I don't know. I go with D. I don't know. The proper technique used.
All right, so we've got a C and we've got an A. Okay, so the answer is C. the financial reporting, the budgeting and operating budgets and all of that is the responsibility of the property management company. Okay. 3, which of the following is cash flow? The total rents plus revenues from other sources generated by a property, or fixed operating expenses minus variable operating expenses, or effective gross income minus net operating income, or net operating income minus debt services and reserves.
I would say D.
Okay, so I see a couple of D's. I have an A. All right, we're talking about cash flow here. All right, what's remaining in your hot little pocket? So the answer is D. Net.
Damn,
Say that again.
that's where my mind was going, but I didn't know if I was right or not.
Well, like I said, you better start trusting your gut. So D is the correct answer. It's the net operating income minus the debt service and reserves. So my question to you is, how did we get to the net operating income?
Revenue minus expenses.
We're saying the effective gross income
Minus expenses.
minus the net
Operating expenses. Yeah.
income. All right, so that is correct. In order to get to net operating income, the first thing is we're getting the gross income, whatever that is. And then we're going to be subtracting the net not the net operating income. We're going to be subtracting the expenses, the operating expenses, and then we'll get the net operating income. And then from there, we take away the debt service and the reserves. And then what's left over is the cash flow, which could be either positive or negative. All right, it can go either way. All right, this is the last question before we take a break. A certain building has a vacancy rate above that of the general market. The most likely reason for this is A, high property tax rates, B, a bad market, C, poor management, or D, lack of incentives from the municipality. Has a high vacancy rate above the general market.
C for sure.
C is the correct answer, poor management, poor property management.
I misread. So yep, I'm catching myself.
Okay. All right.
Thank you.
So we're going to take a break. I'll see you guys back here at 7:55. So before you go, let me just ask you, how are you feeling so far about these questions and your knowledge?
They seem easier to me.
Okay, but you seem to be second guessing yourself a lot.
Oh no.
There was so much to learn, I have to say.
Okay. Anybody
It's
else?
always, I'm learning every time. Yeah, it's like constantly learning something new and changing my strategy, how I think, how I look at it. It gets easier. It gets easier as we're doing more and more, I think.
Okay.
I can, yeah.
Ronak.
Okay, so we have 50-50. We have some that say it's easy, some that say that they're learning. All right, good. So we're going to continue because this is the only way that you're going to be able to remember. Because again, you have to know the subjects, whatever subjects we're choosing here. So we're going to continue after that. So I'll see you back here at 7:55.
Yeah, thank you.
Great. You're welcome.
Thank you. Thank you.
You're welcome. Okay, so is everybody refreshed? Everybody good?
Yes.
Yep.
Good. All right, so we'll move forward to something environment, which is kind of important for us in our area. Okay, and so here we go. Which of the following is part of the makeup of the New Jersey Real Estate Commission? 3 licensed New Jersey brokers with 10 years experience, 2 representatives of the governor, 2 members of the public with 10 years New Jersey residency, or 7 total members.
C.
Okay, is that C as in cat?
Cat.
Yep, that is correct. All right, so what is the term length of a commissioner? Is it 3 years, 2 years, 5 years, or as long as the governor wants?
D.
B? No.
No, commissioner. Oh, not the government representative. Commissioner.
Right, we're talking about the real estate commissioners.
A, 3 years.
Ding, 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 ding. Good job. A is the correct answer. Okay. Which of the following is not one of the New Jersey Commissioner's responsibilities? A, regulating licensing of brokers. B, regulating the sale of New Jersey advertised out-of-state properties to New Jersey residents. C, administrating the real estate guarantee fund. Or D, establishing reciprocity agreements with other states.
D.
Is that dog, boy?
I was thinking dog, but we don't
Dog.
have reciprocity, right?
All right, so D, dog is the correct answer, establishing reciprocity agreements with other states. Okay. Number 4, which of the following activities must follow another set of regulations in addition to those related to real estate transactions? So A, collecting rent, B, procuring prospects, C, selling mobile homes, or D, exchanging real estate.
Cat.
Cat, okay.
Yep.
Cat. Anybody else? 2 cats. Anyone else? All right, so cat is the correct answer. Selling mobile homes is the correct answer. Number 5, to conduct real estate business, a corporation must A, require each officer or partner to pass the licensure examination, or B, have at least one officer hold a broker's license, or C, carry professional liability insurance, or D, first obtain a salesperson's license.
Boy.
Okay, anybody else? All right, we got a lot of boys. The answer is correct. All right, have at least one officer hold a broker's license. Number 6, which of the following statements is true regarding unlicensed assistants? They may not compute commission checks. They may conduct open houses. They may follow up on loan applications, or they may screen walk-in prospects in an interview. All right, we got 2 Cs, we got 1 A, 3 Cs. All right, the answer is C. They may follow up on a loan application. Okay, to obtain a broker license, the applicant must do what? Hold a bachelor degree from an accredited college or university. B, have 3 years of full-time experience as New Jersey licensed salesperson. C, request license issuance within 2 years of completing pre-licensed coursework. Or D, complete the 75-hour pre-license course.
Boy,
Okay. Yep. Ding, 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 ding. Have 3 years of full-time experience as a New Jersey licensed salesperson is the correct answer. Number 8, an active duty military member may have which of the following broker license requirements waived? A, education, B, experience, C, both education and experience, or D, none of the above.
boy.
B.
B,
Boy.
experience, ding, 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 ding. That is the correct answer. If a real estate license is not renewed by the expiration date, what happens? The licensee is revoked, the license expires, the license becomes inactive, or none of the above.
Cat.
Cat, good job. Ding, 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 ding. That is the correct answer. The license becomes inactive. Yes, Ravender?
No, sorry, I didn't say.
Okay, you're fine. All right, Tom's initial broker license was issued on August 18th, 2017. When is Tom's license renewal deadline? August 17, 2019, June 30, 2019, July 1st, 2018, April 30, 2019.
Boy.
Boys, ding, 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 ding. Okay. So that's June 30th, 2019, or June 30th of the odd year. 11, Tom's initial, oh, I just did that. Oh, that's a deep, no, it's not that. Oh, right, okay. Tom's initial broker license was issued on August 18th, 2017. When is the deadline for Tom to complete the continuing education?
Hey,
Hey, good job. April 30th, 2019, or April 30th of the renewing year. What are the reactivation requirements for a license that has expired after being inactive for 2 years? Completing continuing education and then renew the license, complete continuing education requirements and have the broker renew the license, complete a reinstatement form, pay the reinstatement fee, and have the broker renew the license, or D, complete all requirements for initial license.
The D. Dog.
Okay, is that what everybody else is saying? All right, Leanne, Hannah, Melissa, ding, ding, ding. D is the correct answer. Complete all requirements for initial licensure. Okay. A referral, number 13, a referral agent wants to convert her license to a salesperson's license. The agent has not been previously licensed as such. If this agent must complete 24 hours of continuing education, she must have been licensed for this would be a guess on everybody's part.
I would just guess is 1. A, like less than 1 year.
I know the good guesses, but the correct answer is 1 to 6 years. And it's now up to 30 hours of continuing education. So in order for them to get their license. All right, so number 13. Okay, number 14. Of the 12 required hours of continuing education coursework, how many hours may a referral agent complete in electives? Well, that's a good question. Any guesses on that? Again, it's going to be guesses, I'm sure.
Dog.
Dog is the correct answer. Ding, 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 ding. Because if you're a referral agent, you have to do all of your 30 hours of course subjects. Okay, number 15. Pete is in active military duty and has received a waiver for his continuing education requirements. When must Pete make up his waived core courses?
Is it A?
A, no.
D, I guess.
No, the answer is never.
Yep, D, dog.
Dog, because
Yep.
the continuing education was waived. So
Yeah, trick question. Tricky. How they worded it.
tricky words, absolutely. But the education was waived, so he doesn't have to do that. Okay, if a person suffers a monetary loss as a result of a licensee's unlawful action and the person wants repayment for the loss, what must that person first do? A, file a complaint with the commission. B, file for a civil court judgment. C, provide certification to the commission of a criminal complaint filing. Or D, apply for reimbursement from the guarantee fund.
How much? File a complaint first.
No.
A or D?
Well, it's not A. Okay, that's not, A is not the correct answer.
Is it D is in dog?
No, that's not the correct answer either. The correct answer is file for a civil court judgment. Okay, they have to file for a civil court judgment first, try to collect on it, okay? And then they are going to include the real estate commission as part of the lawsuit. They're going to then file a criminal complaint because they didn't collect on the judgment. And then the real estate commission will do what they have to do regarding the funding from the guarantee fund. All right, Louise's wrongful actions caused both the property seller and the buyer to each lose $25,000. They have both filed complaints and followed the process for reimbursement from the guarantee fund. How much will the fund pay these injured parties?
A?
No. How much? What is the max offense?
Oh, max.
B.
Okay. But we're talking
Would it be C?
C, that's correct. Total of 20,000 for both because it's the seller and the buyer.
Right, okay.
Okay, so you are correct. C is the correct answer. How much is a broker required to pay at the initial licensure to the guarantee fund?
B as in boy.
Is in
20, yeah.
20, yeah.
ding, 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 ding. All right. A little okay, a little good, right? Okay, so again, these are all questions from chapter 1 through 4. Okay. So there's all the answers. This is going to be in the Google Classroom, so you'll be able to access it because there's 1,001 other questions in there. Okay, so let's talk about brokerage regulation. Which of the following applies to independent contractors and not to employees? A, receive health benefits from the broker. B, pay own income tax. C, covered under broker workers' compensation insurance, or work specified hours each week.
Boy,
Yeah. B.
Pay your own income tax, correct? Ding, 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 ding. Which of the following is most likely not included in an employment agreement? A, the licensee's compensation rate. B, provisions for changes to the agreement. C, the agreement termination date. Or D, the length of time the broker must keep the original agreement as part of his or her records.
cat.
C.
Okay, C is not the answer.
Is it B?
Provisions for changes in the agreement, no, that's in there.
D.
I guess D, dog.
Dog. Yep, the length of time the broker must keep the original agreement. That's not in the contract. The compensation rate is in the independent contract agreement. The provisions for changes to the agreement is in the agreement. The agreement's termination date, that depending on how they write up the contract, but typically they write up some brokerages write it up for a yearly contract, and some have it as an automatically renewing contract, and others have it that when the contract is up, you rewrite a brand new one. So you renegotiate the next year's contract. So again, that's something that you need to look at when you're signing on with brokerage companies. Number 3, what steps must a salesperson take when suing a client for failure to pay compensation? A, send a 7-day notice of intent to sue. B, file a complaint with the commission and then the applicable court. C, both of the above. Or D, neither of the above. Salespersons cannot sue clients.
I think it's a D.
Okay, anybody else?
D is, yeah, because the broker, I guess,
D.
we could do.
Okay, so the answer is number 3 is neither of the above. Salespersons cannot sue the clients. All right. Number 4, who may bring action in court against a client for non-payment of owed compensation? A, only the broker. B, only the licensee handling the transaction. C, only the commission. Or D, either the broker or the licensee involved in the transaction.
The broker.
I think A.
Is it A?
A.
Hey, ding, 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 ding.
A, yes.
The broker. We answered that up above. All right, under New Jersey law, when is compensation due to a licensee? A, at the transaction closing. B, within 10 days of the transaction closing. C, within 10 business days of the broker receiving the associated funds. Or D, within 10 days after the funds have cleared the broker's account.
B.
Boy.
Boy. I think it's C.
What did you say, Hannah?
I didn't.
C, Kamini, Casey, C.
Is D.
C.
10 days after the fund have been cleared.
Nope. Whoever said cat within 10 business
B or
days
C.
of the broker receiving the associated funds, ding, 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 ding. Okay, under New Jersey law, when is compensation due to a licensee? Within 10 business days that the broker received the associated funds. And then ... or upon the check clearing. All right. Which of the following statements is false? Only sellers of residential property may receive a rebate. B, only closing agents may provide a rebate. C, the broker and seller must agree to the terms of the rebate in writing. And D, the broker must disclose the rebate to the mortgage lender.
Boy.
B and C looks B and D looks good. Broker might disclose. Lend only closing agent might provide your rebate. I don't know.
That's not a good sign, Hannah.
I'm sorry. Yeah. I need to review. I need to do. Yeah, I have to do a lot.
We have a lot of B's. Okay, so we are on, which is false. Okay, that's the key word here, false. And the answer is the broker must disclose the rebate to the mortgage lender. That is not true. They don't have to disclose the rebate to the lender, but everything else is correct. The sellers of the residential is also, wait, the following statement is false. Only sellers of residential property may receive a rebate. Sellers can't receive a rebate. Okay. Closing agents may provide a rebate. The broker and seller must agree. That's true. The broker must disclose. I don't know how they have this worded. It doesn't make any sense. Let's see what they have here. All right, they've got it as D, but in this case, I guess it's the way they worded it. The broker must disclose the rebate to the mortgage lender. The answer is no, they don't have to disclose. All right. And just so you know, for your own edification, A, sellers of residential property may not receive a rebate. It is only the buyer that is receiving the rebate on their primary residential property, just so we have that all correct. All right. Everybody good with that?
So the answer is A or D.
The answer is D, because the broker must disclose the rebate is not true. They do not have to disclose the rebate to the mortgage lender. All right. But the other one that's incorrect also is that only sellers of residential property may receive a rebate. That is not true also. Okay. So they have two false ones, but here it's basing it like it's the law. They're phrasing it as if it's the law, and the answer is it's not the law to disclose it to the mortgage lender. All right, it's the way they phrase the words. Okay, which of the following is not an example of price fixing? Two brokers discussing what commission rate each charges. Two brokers agreeing to pay a set referral fee. Two brokers setting the same commission percentage to charge all clients, and a broker telling a client the commission rate being charged is the standard rate. Boy, that's a tricky question. and tricky answers.
Is C or D?
No, C is price fixing. D is price fixing.
B, two broker agreeing to pay a set referral fee. Referral fee is set. It could be.
They're not set. That again is price fixing.
They not set. Okay. Oh gosh, that's right.
About the A.
The
Two
correct
broker.
answer is A. They're not supposed to be doing
Yeah.
out of all of these answers. The correct answer is two brokers discussing what commission rate each charges. So they're not saying that I absolutely charge such and such amount. They're just saying this is what we charge. So they're not saying that we're both going to be charging the same amount of money. So again, it's a very tricky wording. All right. If a broker receives $15,000 in cash from a client as earnest money on a specific property, what must the broker do? A, deposit the cash into the broker's business account immediately upon receipt. B, reject the cash and request a cashier's check for the earnest money. C, report the payment to the New Jersey Real Estate Commission. Or D, report the cash payment to the IRS.
Dog.
Mm-hmm.
Dog. Ding, 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 ding.
Dog. Yeah.
That's correct. All right. Number 9. Does anybody know why?
Yeah, there's a IRS 8300, section 8300.
Over 10,000, right?
Over 10,000 they have to report.
Yeah.
Cash report.
Do we know? Okay, so yes, we all know that number, but do you know the reason why?
Money laundering. To avoid.
And terrorist acts.
Yeah.
It's called the Patriot Act is what it's called. And that's what's saying that we have to do that. All right, when a broker charges more than $25 for an advance fee, the broker must provide the client with an accounting of how the money was used. The broker must do this within blank of receiving the fee. A, 30 days, B, 90 days, C, 60 days, D, 10 business days.
B.
No.
Hey,
A.
30 days.
30 days.
No.
Dog?
No?
No. Serious?
Then I don't.
This-
Oh gosh.
This is at the end of chapter 1.
Is not dog?
Nope, it's not dog.
Not A, not D. Now is B and C, right?
That's correct.
Mm-hmm.
Go with boy.
Oh,
Elimination
Nine.
down.
So the answer is 90 days.
oh.
90 days. All right, that's the end of chapter 1 under rental referral agencies. Okay, broker must keep all records related to trust accounts for at least A, 6 months, B, 1 year, C, 3 years,
Dog.
and dog.
Dog.
That's it.
Dog.
Dog.
All right, 6 years. Okay, which of the following statements is true? A, all advertising by a salesperson must include the employing broker's telephone number, office telephone number. B, brokers may not use nicknames on advertising. C, cell phone numbers used in advertising must be accompanied by the broker's office number. And D, advertising that includes reference to home offices must also include the broker's business name.
D.
C, I guess.
Ding, 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 Ravender. C, cell phone numbers used in advertising must be accompanied by the broker's office number. All right, so that's the correct answer. Okay, 12. Advertising that includes a commission rate must also include the wording, A, in New Jersey, commissions are negotiable. B, in New Jersey, commissions are negotiable to a qualified buyer. C, in New Jersey, commissions are approximate or estimated. Or D, in New Jersey, commissions have a standard rate.
B, boy. No? Qualified, they had to write qualified buyers up there.
D for dog.
I say A.
That's a great answer, Melissa. Ding, 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 ding. Commissions are negotiable, period. End of story.
Don't they have to write somewhere only to qualified buyers? What was that for?
Well,
That is
the
for
qualified buyer is
mortgage?
not writing- the qualified buyer has nothing to do with the commission. Do they?
That must be the
That's-
interest or like
How-
mortgage or something.
It must
How
be,
about if the seller is paying commission, not a buyer? So
okay.
that's why.
And didn't we say that there is no such thing as a standard rate,
That's
No.
why.
approximate or estimate?
Nope.
No. Okay, and here, this, what threw you off to a qualified buyer is when we have the trigger terms, right? So if you're gonna talk percentage, payment amount, and this and that and the other, again, it comes under mortgages or financing. That's where it's always going to have to say to a qualified buyer.
Got it.
Okay, number 13, which of the following statements is, did I just read this? No, which of the following statement is true? CMAs are equivalent to appraisals. B, appraisals may be offered for free. C, advertising that includes reference to a CMA must advise consulting with a tax professional. Or D, advertising may reference CMA.
Is it boy?
D.
It's not boy.
Hmm.
Dog.
Ding, 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 ding. In an ad, you can put in free CMAs or what's your home worth or what is the value of your home. You can advertise that.
So
Appraisals,
it's D.
D is the correct answer. So appraisals are never free and we don't do appraisals. Advertising, number 14, advertising that contains reference to a home warranty must state if A, the warranty is required, B, the seller is responsible for fees related to the warranty, C, an appraisal is required, and D, none of the above.
D.
Well, that would be one of my choices. Again, this isn't a good answer. These are not good answers. All right, anybody else with a
D.
answer? D, dog, none of the above? No,
Yep.
no, the
Yeah,
correct,
I already told before.
I'm sorry? What was that, Kamini?
Is D is not correct answer?
Well, D is not correct. That is correct because if you're advertising about a home warranty, what this word should have been,
Mhm.
that the inspection is required. If the home warranty requires
Okay.
inspection. All right.
Mhm.
But the if you're advertising a home warranty, you need to you need to include that in everything. All right. And in this if the home warranty had an inspection, all right, then in that case, the inspection is required, would have to be part of the advertising. So they wrote in the wrong word.
Mm.
All right. So
Mm.
that's must state if the inspection is required. In the ad, it must state that, as well as on the right signs that go on the for sale signs. That must also have it on there. Okay. All right. Number 15. Developers of out-of-state properties selling the properties in New Jersey must A, have the properties inspected by an inspector licensed in New Jersey. B, file a registration application with the New Jersey Real Estate Commission. C, only advertise the property in English. Or D, file a public offering statement with the Bureau of Subdivided Land Sales.
Is it boy?
Boy,
Nope,
A por apple.
nope.
Now it's D.
That's correct. D is the correct
File a public declaration with the Bureau of Subdivided
public
Land
offering statement with the Bureau of Subdivided Land Sales belongs to out of state.
Developer of out of
Okay,
property selling property in New Jersey by a public.
okay. So D is the correct answer. The Bureau of Subdivided Land Sales, A, regulates certain interstate property sales. B, investigates unauthorized advertising of interstate properties in New Jersey. C, regulates brokers' compliance with the New Jersey Real Estate Full Disclosure Act. Or D, all of the above.
It's a dog.
Dog, ding, 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 all of the above. All right, so that takes care of that. All right, now how are you feeling about all of this now? Is it
Good.
helping you?
Yeah.
Okay. All right, that's only one person that answered.
Yes. What was number 14? No.
The warranty is required,
Okay.
right? But the correct, it should be corrected, and I'm going to see if I could correct it. It should say if the warranty requires an inspection, right, then it must be stated in the advertisement. Okay, so if the warranty requires an inspection, then that must be stated in the MLS as well as a regular advertisement.
Thank you.
You're welcome. All right, so business practices. All right, so here we go. What is the, this is good. What is the very first disclosure licensees are required to provide to customers? Proof of the licensee's current license, dual agency disclosure, customer information statement, or broker fee disclosure?
CIS.
Is this
Ding,
yeah.
ding, ding, ding. And the correct answer, if the correct answer was there, what is the correct answer as to when you have to provide the CIS?
Oh, we went over that too.
When there's interest?
Okay, and so you would need to elaborate that because interest wouldn't be sufficient. The correct answer is when the buyer is showing motivation and financial discussion is the correct answer. All right, so it would have to include all of that. And I don't know where, okay, where do I have CIS? I know I labeled it, hold on. I'll show, yeah, here it is, page 47. So that we have the correct answer. Oh, okay. 647, here it is. No, that's, wait, what's that? No, It's before that then. Yep, here it is. Furnish a consumer information statement before any discussion of whether seller, landlord, buyer, tenant, motivation, or financial situation is initiated. That is the 100% correct answer, and that could show up in somebody's test exam. All right, because that is they want that, they like that wording. All right. Okay, how long must a broker keep a signed CIS? So that's a good question. I don't know that answer.
I'm guessing 6.
6 years, I guess.
Okay, so the answer is yes, 6 years. However, okay, however, that is only if there was a transaction. All right. So if we're just talking to buyers and showing houses to buyers, and that is it, then the broker does not have to keep that for 6 years. But if we have a transaction, right, and we're representing the buyer and we have a CIS, then and we have a transaction and we're representing the seller, then the CIS needs to be kept for 6 years. Okay. And there again, it's over here. If the CIS is signed, a copy of the signed CIS is to be retained by the broker when a sale or rental is consummated and for 6 years. Okay, so that's the 100% correct answer. Okay, when an agency agreement is established through the actions of the involved parties, this means the creation is called what? A, expressed authority, B, implied authority, C, apparent authority, or D, contractual authority.
Dog.
Dog.
Okay. Anybody else? Okay.
The action, so be implied.
I'm glad
Action.
you brought that word up.
B.
Ding, 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 ding. Implied is action. Express is verbal. Apparent, I have no clue. And contractual does not come into this equation at all. So B, implied, is actions. If you were at an open house, you were doing the open house and you were doing the listing, you were the listing agent. No, you were doing an open house for the listing agent, and the buyer comes in and you're talking to them and they are thinking that you are helping them because of your actions. What kind of implication is that?
Oh.
Hannah, sounds like you just woke up.
Actually did. What kind of implication is that?
Yeah.
Action. Yeah, that you are their agent, so that the client implied action. Oh my goodness.
Okay, think it through. I'll repeat it again. You are doing an open house for a listing agent, and a buyer comes in, and through your actions of what you're doing and talking and all of this, just everything, all right, what is that implying? And it is an action.
Expressed through
that-
talking.
No.
Isn't that
I don't-
contractual, right?
All right, so the buyer thinks that you're their agent, right? So that through your actions, you're implying that. But what else are you implying? again, through your actions, what else are you implying?
That you want to buy the house?
No, the listing, the agent doing the open house. Through their actions, the buyer thinks that this agent is their buyer. I mean, it's their agent. Okay, what are you implying? Bottom line is undisclosed dual agency.
Oh, okay.
All right. Again, you need to think it through. I stated that this was the agent doing an open house for another agent, and a buyer came in, and through that agent's action, they think that he's their agent. And that's the actions of doing whatever it is, talking, whatever. Right? The answer is undisclosed dual agency. Illegal. Can you get into trouble? Absolutely. All right. So, and that could be implied, that could be expressed. It all depends on what is happening at that time. Bottom line though, it's undisclosed dual agency. Okay, which of the following business relationship is not an agency at all? A, disclosed dual agency, B, transaction broker, C, seller agency, D, buyer agency.
I would say B, the only thing that doesn't say agency on it.
Ding, 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 ding. That's the correct answer. But now let me ask you, forget the agency. Why would B not be an agency?
To be honest, I haven't touched that chapter yet,
Gotcha.
but
Okay, I'll accept that.
I'm thinking the only thing that made sense to me is the main word on there is agency and
Right,
broker.
that's not a good answer. So
Okay.
I understand. I'm not faulting you. The reason the transaction broker is not an agency is because the transaction broker does not owe any fiduciary duties to either side. They're not representing either side. All they're doing is just the paperwork, bringing two people together and making sure that with the paperwork and them being on top of it, the transaction is going to go through.
Okay.
All right.
Thank you.
You're welcome. And that's what transaction broker is. Okay, so you have no fiduciary duties, no legal responsibilities, no legal obligations. Whereas with seller agency, buyer agency, you have all of those. And disclosed dual agency, again, in Gloria language, you are basically Switzerland. So in a way, you are a form of transaction broker. But because we have a signed contract with the seller and we're getting paid by the seller, we still have a fiduciary obligation. Okay, there's still an agency involved because we do have a fiduciary obligation to the seller who's going to be paying us. Okay, what document includes information on completion dates for interstate property improvements? Okay, so A, public offering statement, B, property condition disclosure, C, property physical condition disclosure, or D, consumer information disclosure. Oh, okay.
Is it A?
Ding,
A
ding,
or C?
ding. Was that your first choice?
Yes.
Ding, 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 ding.
Or-
Good job. Public offering statement, right? Because it's an interstate property. Okay. Number 6, licensee lieu has discovered that the homeowner of the property his client wants to buy has been convicted of murdering a delivery driver on the property. Holy crow. When must Lou disclose this to his client? Prior to submitting his client's offer, prior to showing the property to his client, C, immediately upon discovery, or D, not required to disclose this information.
Dog.
Dog. Okay, we got a dog. Anybody else? Well, I guess the correct answer is dog. He is not required to disclose that information. Okay. Number 7. I'm going to put this in here because I want to see what happens. All right, number 7. What is a latent defect? A defect that does not impact the overall condition of the property. B, a defect that would not be discovered in an ordinary inspection. C, a defect that the seller has failed to disclose. Or D, a defect the licensee knows about but does not disclose to the buyer.
Boy.
B. As in boy. Yeah.
Okay, so we have 2 Bs. Okay, there's 19 people here.
All right, I'm gonna take a lucky swing. I'm saying dog.
Okay, I'll accept your dog, but I'll bid you a B for boy. All right, so boy is the correct answer. A defect that would not be discovered in an ordinary inspection. Okay, all right. So that's that. So now we're going to number 8. Okay, so the New Jersey New Residential Construction Off-Site Conditions Disclosure Act. Okay, the new Off-Site Conditions Disclosure Act requires that a list of off-site conditions that may affect the property be A, provided to the potential buyer prior to submitting an offer. Okay, B, included in the property condition disclosure. C, included in the property listing. Or D, available at the municipal clerk.
It's either B or C.
Okay, remember this is new residential construction.
Is it D? As in dog?
Ding, 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 ding. That is the correct answer. It's available at the municipal clerk's office. All right. We're not providing it's done after. How many days, if this is a new construction contract, how many days does the buyer have to cancel?
7.
Ding, 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 ding. Good job. Good job, Hannah. All right.
Thank you.
Number 9. If a property seller disagrees with the Attorney General memorandum, what must the licensee do? A, make note of the seller's disagreement on a copy of the memorandum. B, have the seller sign a disagreement form. C, watch the seller carefully during the transaction to detect any signs of discrimination. Or D, refuse to take the seller's listing.
A is an apple.
Really?
Oh my goodness.
Boy.
I
That's a
tell you,
Yeah.
Boy.
I tell you, sometimes I just don't answer because I go blank.
So reread
Thank you.
question. Okay, so everybody, and I mean everybody, reread the question and the answers. I'm going to pretend I didn't hear anything.
B as in boy.
Boy.
I guess D. I don't know.
Melissa, was that a boy or a dog?
Dog.
Thank you.
Oh, so it's D.
Dog.
Okay.
Dog. You're all dogs because you didn't get the right answer. Woof, woof. Right? What is, so let me ask you. Obviously, you're not understanding because
Because
you,
the Attorney General memorandum, so that's why.
what is the Attorney General memorandum? What is it about?
I don't know. It must be some serious stuff though, so that's why you gotta reject it.
State.
When we go give a listing, when we go get a listing from the seller, what is the Attorney General memorandum about?
I'm gonna tell you. Hold on.
Yeah, you're looking it up. You don't know it.
Mm-mm.
Uh-huh. Okay.
Yeah, I don't know it.
What is the Attorney General memorandum about? We've gone through five weeks and nobody knows what that is about. Then I must be a terrible teacher.
You actually not, but I really don't like. I really have brain fog with that. I really don't remember.
The Attorney General memorandum is
Fair
about
chance in
the
the housing act.
law against discrimination,
See, yeah. I don't know.
right? So are we going to make a note about a seller wanting to discriminate? We're not going to be.
No.
No, we just gonna reject it.
Yeah.
Reject.
Absolutely. Do you want to be a part and parcel to a lawsuit of discrimination?
No. Is that the Fair Chance in Housing Act? That?
That's part of it.
Okay, okay.
That's all part of it. Yes, absolutely. So, no offense, but you all better read the you better read the Attorney General memorandum, because if you're going to get listings, you better know what it's about because you are signing that document as well. All right, it's not just the seller that's signing that document any longer. It is now the seller and the seller's agent. And so you better understand what is the New Jersey law against discrimination. What are we not allowed to discriminate against? Let's talk about that.
Everything, race, color, religion, all that, right? That's
Well,
what you're talking about?
well, I don't know. Is that what I'm talking about, Melissa?
Demographics, all that stuff.
Okay, so am I allowed to discriminate against a mom with a 14-year-old child?
No, any.
Am I allowed to discriminate against anybody who's getting government subsidies?
Nope.
Nope.
All right. That's just the basics of it. Can I discriminate against a woman breastfeeding?
No.
No, it's in the law. All right. So if you don't remember it, I highly suggest that you guys read it. Maybe we'll do that tomorrow. All right. That's very scary. That's not I'm scared. All right. So Attorney General memorandum is basically about the New Jersey law against discrimination, the biggest hot button, which it was rewritten last year, which was including that we cannot discriminate against people getting government subsidies, such as Section 8. All right, and that's a very big hot button. All right, let's try to move forward so that I can recoup myself. When an agent examines other properties similar to the listed property to determine the appropriate selling price, what is that process called? a property appraisal, a property inspection, a market value study, or a comparative market analysis.
Is it
Dog.
dog?
Dog, ding, 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 ding. Okay, we're getting a little bit better. When many licensees inform buyers that a list of sex offenders living in the area is available at the county prosecutor's office. A, at the time of the property showing. B, when signing the agency agreement. C, prior to submitting an offer on a property. Or D, after the sale is final. When may the licensees inform buyers / tenants of the list of sex offenders living in the area is available at the county prosecutor's office?
I feel like that's a trick
It'll
question.
be A. Yeah. A.
Why?
But aren't you not supposed to disclose that?
Yeah, that's what I thought too.
No kidding. So when, if at any time are you going to be able to talk about it? Let's rephrase.
Oh, after the final sale.
Ding,
right?
ding, 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 ding.
Right.
All right. I'm not saying we're able to talk about it. I'm not saying that we should be talking about it, but when, if at all, can we talk about it? The only time is once the property transferred ownership to the buyer, or once the property transferred possession and occupancy to the tenant. All right. And only then will the Attorney General or the county prosecutor's office let those people know if there is a person living in that neighborhood. We will never know about it, but the people that are in these new properties, if there's anything like that, they will find out about it, whether it be in person or they get a mailing, a letter, certified letter. Okay, number 12. Which of the following obligations does an agent have to a client, but not to a customer? So the keyword obligation. A, confidentiality. B, honesty. C, disclosure. D, reasonable care.
Let's see.
Legal obligation.
Wait, so honesty, you saying?
A or D?
Good choices, Ravender. Good choices.
Dog.
Confidentiality. A.
Hey, ding, ding, ding,
A.
ding, ding. Thank you, Junwa. Thank you very much. Confidentiality to a client. Keyword, obligation to a client and not to a customer. Right? What do we owe a customer? Honesty, reasonable care, and to everybody, we owe disclosures. But if it's a client, we owe them confidentiality. That's our legal obligation based on the law of agency. Okay. All right. Number 13, the Truth in Lending Act and blank require consumer credit institutions to disclose actual credit terms and rates to borrowers in writing.
Thing is, boy.
Boy, ding, 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 ding. Regulation Z. Good answer. Ding, 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 ding. Okay, number 14. When advertising financing information, which of the following would not require additional disclosures? A, percentage of down payment, B, finance charge, C, loan assumption at a specific percentage rate, or D, number of payments to repay the loan.
D.
D, dog.
Okay. France, did you say cat?
No, I said D as a dog.
Dog, okay. Well, the dogs aren't doing too good today. So dog is not the correct answer. Anybody else?
Oh, it says would not require. Okay.
Right, would
Okay.
not
Yeah.
require additional disclosure. So here we're talking about trigger terms.
Is it loan assumption?
Ding, 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 ding. But not just
Ding.
that. It's C, cat, meow, loan assumption, specific percentage rate, which means we are talking about the annual percentage rate, APR. So it's the loan assumption plus the APR rate. All right, would not need to have additional disclosure, right? Remember we had trigger terms? Does anybody remember that? All right, that must be chapter 2, towards the end. Violations, procedure, probation, advertising. Buyer, where's the trigger terms? Chapter 4, let's go for that because I know it's in here. All right, it's not in here. It's going to be in the, I know it's in here, but I can't find it right now. But it's trigger terms. Oh, I wonder if I could do trigger terms. Okay. Yep, here we are. Okay, triggering terms. So if we have the amount of the percentage of down payment, we need to spell it out. The number of payments or period of repayment, we need to spell it out. The amount of any kind of a payment, we need to spell it out, or any amount of finance charge, we need to spell it out. But if we're talking about an APR rate, okay, then the APR, what would not be considered a trigger term is assuming a 5% annual percentage rate loan, because that's already including all of the closing costs and you're assuming the mortgage. All right. Everybody good? Are we surviving this?
Yes.
Good. Okay. Rental referral agency is required to check the availability of properties. Which of the following updating requirements is correct? A listed only property every day, an advertised property every day, an advertised property every 3 days, or an advertised and listed property every 3 days.
Boy.
Is it?
Boy is the correct answer. Ding, 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 ding. Okay, boy is the correct answer. An advertised property every day. Okay, and does advertised property, does that also include MLS as an advertisement?
Yes.
Yes, 100%. Okay, all right. Number 16. Penalties for violating the Consumer Fraud Act includes what? A, $20,000 for the first offense, B, 50,000 for second and subsequent offenses, C, arrest for failure to pay penalties, or D, 4 times the amount of damages awarded.
That looks like B. If I'm not mistaken, penalty violation, consumer fraud. 50 for the second and subs. Oh, I don't know right now. Sorry.
Keyword include. What else does it include? All right, the answer is arrest for failure to pay penalties. So you could be fined $20,000 for the first offense. I don't know what the actual numbers are right now, but any of those numbers, plus in addition, you could be arrested for not paying any penalties. All right, that's the Consumer Fraud Act. All right, number 17, making an untrue statement of fact, okay, without knowing the truth is considered what? A knowing omission, an unintentional misrepresentation, a negligent omission, or a voluntary misrepresentation.
Dog.
An untrue statement.
Is it A?
So,
More like A.
Okay, let's read the question. Reread the question. Making an untrue statement of fact without knowing the truth.
Unintentional, right?
Unintentional.
Ding, 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 ding. Finally, that is correct. Unintentional. All right, we got to read the words. I know we're all getting tired, but it's going to be 4 hours for you to take the test. All right, so we're in practice mode here. Okay, so unintentional is because you stated an incorrect statement. You did not know the truth, and so you did that unintentionally. It couldn't have been voluntary because you didn't know the truth. All right, couldn't be negligent omission because you made a statement. Knowing the omission, again, you did not know it. So the only answer to that is unintentional misrepresentation. Okay, number 18, what penalty may be imposed when a licensee has been deemed a repeat offender in violating the license law? $5,000, probation, denial of future license issuance, or imprisonment?
The cat.
that
Ding, ding, ding. Good job. You can't get your license. 3-peat is the no 3-peats. All right. Which of the following is not a violation of the license law? So, which is not a violation? A, promoting the sale of real estate through a lottery. B, paying a rebate to a residential property buyer. C, not disclosing the licensee's own interest in the property for sale. And D, commingling funds that belong to others with the broker's own funds.
boy.
Is it C?
Okay, anything else?
I say A as an apple.
Okay, so the answer is B as in boy. The following is not a violation of paying a rebate to a residential property buyer. The law says that we are allowed, the selling broker is allowed to pay a rebate to a residential property buyer, ... must be a primary residence. Okay. So promoting the sale of real estate through a lottery is illegal. not disclosing your own interest in the property for sale, illegal. Commingling funds that belong to others with broker's own funds, illegal. Okay. Number 20, who investigates a licensee's actions for possible law violation? A, the supervising broker, B, the attorney general, C, the real estate commission, or D, none of the above.
See, as a cat.
I said cat. Yeah.
Ding, 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 the real estate commission. And how do they do that? How do they do the investigation?
Testers. Through the
Testers.
testers? Yes.
Good job. Ding, ding, ding. Testers, volunteers. Okay. Is number 21. And okay. Is representing more than one party in the same transaction a license law violation? Is representing more than one party in the same transaction a license law violation? A, yes, if disclosed. B, yes, if undisclosed. C, no, if undisclosed. And D, never.
Boy,
Representing.
I'm gonna go with boy as well.
boy.
Good job. Good job. B is the correct answer. Yes, it is a violation if you do not disclose that you're representing both parties. All right. All right. So we're going to quit. We're going to quit tonight, right now. Okay. It's been, you've done well in answering. Okay. So we're going to write down review 2 for the word for today.
Review 2.
Yeah, I can't, just like you, my brain is dead too. So review 2 today, and I will see you tomorrow. All right.
Okay, thank you.
Thank you.
Thank you. Good night.
Thank you. Good night.
Thank you.
Good night.
Thank you and
Right.
good night.
Good night.
Good night.